If you had invented something truly original in 1789, something nobody had ever built before, you would have had no way to protect it. Anyone could examine your creation, build an exact copy, and sell it in direct competition with you without paying you a penny or asking your permission. And there was nothing you could do about it, because no federal law in the United States said that an inventor had any exclusive right to profit from what they had created. That was the reality for every inventor in America for the first 14 years of the country's existence. The blacksmith who designed a better plow, the mechanic who built a faster loom, the chemist who discovered a more efficient way to process raw materials, all of them faced the same problem. They could spend months or years developing an innovation, invest their savings in materials and prototypes, test and refine their designs through trial and error, and finally bring a finished product to market, only to watch a competitor who had invested nothing in the development process walk into their shop, study the design, and produce a cheaper version within weeks. The copier bore none of the development costs. The inventor bore all of them, and the law did nothing to redress the imbalance. This was not merely unfair. It was economically destructive. Without protection, the rational choice for any inventor was either to keep his innovation secret, which prevented it from benefiting the broader economy, or to abandon the effort entirely, which meant the innovation was never developed in the first place. The result was a country that was systematically discouraging the very creativity it needed most. But what makes the story remarkable is not how long the problem lasted. It is how quickly and how seriously the founders addressed it once they had the constitutional authority to act, and how the system they built from scratch became one of the most important engines of American economic dominance for the next 2 centuries. The concept of granting inventors exclusive rights to their creations was not an American invention. It had roots that stretched back centuries in European law and reflected a fundamental tension between 2 competing principles that governments had been struggling to balance since the medieval period: the desire to encourage innovation by rewarding creators on one hand, and the danger of concentrating economic power through monopolies on the other. The Republic of Venice passed what is generally considered the first formal patent statute in 1474. The Venetian Patent Statute granted inventors exclusive rights to their inventions for a limited period, reasoning that if inventors knew their creations would be protected from copying, they would be more willing to bring new industries, technologies, and techniques into the city. The statute was designed as an economic tool, a way to attract talent and investment by promising protection that other cities and states did not offer. It worked. Venice became one of the most innovative and economically dynamic cities in Europe during the 15th and 16th centuries, in part because inventors knew their work would be protected there. In England, the monarchy had a long and often abusive tradition of granting monopolies to favored individuals and political allies. These monopolies were not rewards for invention. They were grants of exclusive control over existing trades and commodities, given to courtiers and supporters as political favors. The holder of a monopoly on playing cards, for example, could prevent anyone else from manufacturing or selling playing cards in England, regardless of whether he had invented anything or contributed anything to the industry. Queen Elizabeth I granted so many of these monopolies that the practice generated enormous public resentment and eventually became a political crisis. In 1624, the English Parliament passed the Statute of Monopolies, one of the most consequential pieces of commercial legislation in the English-speaking world. The statute abolished the Crown's power to grant monopolies in existing trades and carved out a single, specific exception allowing patents to be granted for genuinely new inventions. The term was limited to 14 years, and the invention had to be truly novel, not simply an existing product or technique that the Crown was handing to a favorite. The Statute of Monopolies drew a sharp line between illegitimate monopolies on existing commerce and legitimate protection for actual innovation, and that distinction became the foundation of modern patent law in both England and, eventually, America. In the American colonies, patent protection was haphazard at best, and for many inventors, it was effectively non-existent. There was no unified colonial patent system, no central authority, and no standardized process. An inventor who wanted protection for his work had to petition the legislature of his individual colony and hope that the lawmakers, who were typically landowners and merchants with no technical expertise, saw enough value in his invention to grant him exclusive rights. The process was slow, often taking months or years. It was expensive, requiring legal fees and political lobbying that most ordinary craftsmen and tinkerers could not afford. It was politically dependent, meaning that an inventor with connections to colonial power structures had a far better chance of receiving protection than one who did not. And it was entirely inconsistent from one colony to the next. An inventor who secured a patent in Massachusetts had no protection whatsoever in Connecticut, New York, Pennsylvania, or any other colony. His competitor across the border could build an exact copy of his invention, sell it at a lower price because he had not invested years in development, and take his customers without violating a single law. The colonial patent system, to the extent that it could be called a system at all, was a patchwork of individual legislative decisions that protected some inventors in some places some of the time and left everyone else entirely exposed. The first patent granted in what would become the United States was issued by the Massachusetts General Court in 1641 to Samuel Winslow for a new method of making salt. A handful of other colonies granted patents sporadically over the next century and a half, but the total number of colonial patents issued across all 13 colonies over 150 years was small enough to count in the dozens. The idea that invention deserved protection existed, but the mechanism to provide that protection at any meaningful scale did not. After independence, the situation did not improve. The Articles of Confederation, which governed the country from 1781 to 1788, gave the federal government almost no power over commerce, trade, or intellectual property. Each of the 13 states could set its own rules, and most states had no patent provisions at all. A few states passed individual patent statutes in the 1780s, but these laws applied only within the state's own borders and offered no protection against competitors in neighboring states. An inventor in the newly independent United States faced essentially the same problem he had faced as a colonist. His ideas were unprotected. His investment in development was vulnerable, and if someone wanted to copy his work, the law was on the copier's side, not the inventor's. The men who wrote the Constitution understood this problem with a clarity that reflected both their intellectual sophistication and their practical experience as leaders of a nation trying to establish itself economically. Several of the delegates to the Constitutional Convention were themselves inventors, scientists, or patrons of innovation. They had seen firsthand the consequences of a system that offered no protection for creative work, and they had studied the European models closely enough to grasp both their strengths and their failures. When the delegates gathered in Philadelphia in the sweltering summer of 1787 to draft the document that would replace the failing Articles of Confederation, the question of intellectual property was discussed with surprisingly little controversy. James Madison of Virginia and Charles Pinckney of South Carolina both independently proposed language protecting the rights of inventors and authors, and the convention adopted the provision with minimal debate, a remarkable consensus for a body that fought bitterly and at great length over nearly everything else. The ease of passage was not a sign that the delegates considered the issue unimportant. It was a sign that they considered it so obviously important that it required no argument. A nation that wanted to innovate had to protect its innovators. A government that wanted technological and economic progress had to create conditions where that progress was rewarded rather than punished. The resulting clause was one of the most carefully worded provisions in the entire Constitution. Article 1, Section 8, Clause 8 gave Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Every word was chosen with precision. The clause is remarkable for several reasons. It is one of the few places in the Constitution where Congress is given a specific power tied to a specific stated purpose. The purpose is explicitly identified: to promote progress. The mechanism is equally explicit: exclusive rights for limited times. The protection is not permanent. The rights are not absolute. They exist to serve a public function, the advancement of knowledge and technology, and they expire so that the public eventually benefits from free access to every protected invention. The founders did not leave intellectual property protection to the states or to future political negotiation. They embedded it directly into the constitutional framework of the nation, alongside the powers to tax, to regulate commerce, to maintain an army, and to declare war. The motivations behind the clause were both philosophical and deeply economic. The founders, many of whom were inventors and thinkers themselves, believed that innovation required incentive. If an inventor spent years and significant personal resources developing something new only to watch competitors copy it immediately and sell it for less because they had not borne the cost of development, there was no rational reason for anyone to invest in innovation at all. The free rider problem, as economists would later call it, meant that without protection, inventors would simply stop inventing, or they would keep their discoveries secret rather than sharing them with the world. Neither outcome served the public interest. At the same time, the founders were deeply wary of permanent monopolies, which they associated with the abuses of the British Crown and with the corrupt practices of the East India Company and other monopolistic enterprises. The The British experience had demonstrated that unlimited exclusive rights concentrated power, raised prices, and stifled the very competition that drove economic growth. The compromise embedded in the patent clause was elegant. The government would grant exclusive rights, but only for a limited time. During that time, the inventor could profit from his creation. After the term expired, the invention would enter the public domain and become available to everyone. The system balanced the inventor's need for reward against the public's need for access to new knowledge and technology. Benjamin Franklin, one of the most prolific inventors of his era, took a notably different personal view. Franklin invented the lightning rod, the Franklin stove, bifocal glasses, the glass harmonica, and numerous other devices, but he never sought a patent for any of them. In his autobiography, he wrote that since we enjoy great advantages from the inventions of others, we should be glad of an opportunity to serve others by any invention of ours, and that we should do so freely and generously. Franklin believed that knowledge should flow freely, and that the privilege of invention was its own reward. But the system the Constitution created was designed for a world where not every inventor had Franklin's independent wealth, and where the absence of protection would discourage the very innovation the nation needed to survive and grow. George Washington was the strongest proponent of patent protection among the founders. In his first annual message to Congress in January of 1790, delivered to a joint session of the House and Senate in New York City, Washington urged lawmakers to pass legislation protecting the rights of inventors. He argued that a well-designed patent system would encourage the introduction of new and useful inventions from abroad, as well as the development of domestic innovations, and that both objectives were essential to the long-term economic independence of a young nation still heavily dependent on European manufactured goods and European capital. Washington understood that the United States could not hope to compete with the established industrial economies of Britain and France unless American inventors had both a reason to create new technologies and a legal guarantee that their creations would be protected from theft by domestic and foreign competitors alike. Congress responded with unusual speed, driven by Washington's personal advocacy and by a broad consensus among legislators that patent protection was essential to the nation's economic future. On April 10, 1790, President Washington signed the Patent Act of 1790 into law. It was only the third law that the first Congress passed, right after legislation establishing the oath of office and the tariff system. The speed with which Congress acted on patent law, ahead of legislation on banking, the military, foreign policy, the judiciary, and nearly every other matter facing the new government, tells you how seriously the founders took the issue. In a government that had barely finished organizing itself, that did not yet have a permanent capital city, that was still debating the fundamental structures of federal administration, and that faced pressing questions about defense, trade, and foreign relations, protecting the rights of inventors was among its very first legislative priorities. If you want more stories like this, subscribe. Now let me tell you how the first patent system actually worked. The Patent Act of 1790 created a patent board consisting of three of the most prominent officials in the new government: the Secretary of State, the Secretary of War, and the Attorney General. In practice, this meant that Thomas Jefferson, Henry Knox, and Edmund Randolph were personally responsible for reviewing every patent application submitted to the federal government. The board was authorized to grant patents for any sufficiently useful and important invention, provided the applicant demonstrated that the invention was genuinely new. Jefferson, who was himself an inventor and a man of deep intellectual curiosity, took the role far more seriously than anyone expected. He did not rubber stamp applications. He read them carefully, examined the technical claims, and insisted that inventions meet a genuine standard of novelty and usefulness before he would approve them. Jefferson later hired assistants from the University of Pennsylvania to help evaluate the technical merits of applications, but in the early months of the system, much of the examination work fell to him personally. The Secretary of State of the United States, one of the busiest officials in the new government, was spending his evenings reading patent applications for new types of plows, improved flour mills, and novel manufacturing processes. The first patent granted under the new law was issued on July 31, 1790, to Samuel Hopkins of Philadelphia. Hopkins's invention was a new apparatus and process for making potash and pearl ash, chemical compounds used in the manufacture of soap, glass, and fertilizer. The patent was signed by President George Washington, Secretary of State Thomas Jefferson, and Attorney General Edmund Randolph. For the next 46 years, every United States patent would bear the personal signature of the sitting president, making the early patent documents some of the most historically significant pieces of paper the government produced. Under the 1790 Act, only 57 patents were granted in the 3 years the law was in effect. The examination process was thorough but impossibly slow. Jefferson, Knox, and Randolph were all occupied with the enormous demands of running a new government, and reviewing patent applications was a burden that none of them had the time to sustain. The system was producing quality patents, but it could not keep up with the growing number of inventors who wanted protection. Congress addressed the problem in 1793 by passing a new Patent Act that took a radically different approach. The 1793 Act, largely drafted by Jefferson himself, eliminated the examination process entirely. Jefferson recognized that the personal review system was unsustainable, but his solution swung the pendulum to the opposite extreme. Under the new law, any applicant who submitted a proper written description of their invention paid the required fee of $30 and swore an oath that they were the true inventor received a patent automatically. No government official examined the application for novelty. Nobody checked whether the invention actually worked. Nobody verified whether it duplicated something that already existed. The clerk at the State Department processed the paperwork, collected the fee, and issued the patent. The system was fast, efficient, and required almost no government resources. It also had a predictable and serious consequence. Without examination, patents were granted for inventions that were not new, not useful, and sometimes not even physically possible. Competing inventors received overlapping patents for similar or identical devices. Opportunists filed patents on existing products and attempted to collect licensing fees from the people who had been making those products for years. The courts were left to sort out the resulting disputes, and patent litigation became a growing burden on the federal judiciary. Judges who had no technical training were asked to determine which of two nearly identical patents was valid, which inventor had priority, and whether an invention was genuinely new, questions that Jefferson's examination board had answered before the patent was ever issued. The 1793 registration system lasted for 43 years, and throughout that period the tension between accessibility and quality was never resolved. The system made it easy for any inventor to obtain a patent, which encouraged innovation. But it also made it easy for anyone to obtain a patent for something that did not deserve one, which undermined the credibility of the entire system and made it harder for genuine inventors to enforce their legitimate rights. By the 1830s, the problems had become impossible to ignore. Congress undertook a comprehensive overhaul of the patent system in 1836, passing a new Patent Act that transformed the way America handled intellectual property. The 1836 Act created the United States Patent Office as a distinct federal agency, separate from the State Department and free from the burden of competing responsibilities that had overwhelmed Jefferson's original board. The Act appointed a Commissioner of Patents to head the new agency and established a corps of professional patent examiners, specialists trained to evaluate each application for novelty, utility, and originality before granting a patent. For the first time since Jefferson had personally reviewed applications at his desk 43 years earlier, someone was checking whether inventions were actually new before giving them legal protection. The Act also introduced the modern patent numbering system, assigning each patent a sequential number starting with number 1. It extended the patent term to 14 years with a possible 7-year extension that could bring the total to 21 years. And it established formal procedures for patent disputes, creating an administrative appeals process within the Patent Office itself. The same year, the new Patent Office was established and the modern examination system began. Disaster struck with a completeness that seems almost designed by fate to test the new institution's resilience. On the evening of December 15, 1836, a fire broke out in the Blodgett's Hotel building in Washington that housed the Patent Office, the General Post Office, and the City Post Office. The fire burned through the night, and by morning the building was a shell. Nearly entire contents of the Patent Office were destroyed, including the official records of every patent issued since 1790, the written descriptions and technical drawings submitted by inventors, the correspondence files, the administrative records, and roughly 7,000 patent models. The patent models were perhaps the greatest loss. Under the patent laws of the era, every applicant was required to submit a physical miniature model of their invention along with their written application. These models were not sketches or diagrams. They were working replicas, built to scale, that demonstrated the principles of the invention in 3 dimensions. The Patent Office's collection included models of some of the most important early American inventions, submitted by the inventors themselves. Among the losses were Robert Fulton's original detailed drawings of a steamboat design, rendered in color in Fulton's own hand, and Eli Whitney's original cotton gin model. 7,000 physical representations of American ingenuity, covering nearly half a century of the nation's inventive output, were reduced to ash in a single night. Senator John Ruggles of Maine, who had sponsored the 1836 Patent Act and who had himself been granted one of the last patents issued before the new law took effect, declared that the destroyed documents and models represented the history of American invention for half a century. Congress appropriated $100,000 to attempt restoration of the lost records, and the Patent Office launched a painstaking effort to reconstruct what it could by contacting patent holders, requesting duplicate documents, and searching state and local records. But the reconstruction effort was only partially successful. Many early patents could never be restored because the original documents existed nowhere else. The applicants were gone, their personal copies were lost, and no duplicates had ever been made. Patents from before the fire were later designated as ex-patents by the Patent Office, a classification system that acknowledged their uncertain and often incomplete status. The numbering system started fresh with patent number 1, issued on July 13, 1836, to Senator Ruggles himself for a traction wheel design for steam locomotives. The fire was devastating, but it did not slow the momentum of the American patent system. The new Patent Office, rebuilt and reorganized under the 1836 Act, became one of the most important institutions in the federal government. The professional examination system restored credibility to the patent process and ensured that patents represented genuine innovations rather than paperwork exercises. As the Industrial Revolution accelerated in the United States during the 1840s, 50s, and 60s, the Patent Office became the clearinghouse for the technological creativity that was transforming the American economy. The numbers tell the story of that transformation. Under Jefferson's examination system, 57 patents were granted in 3 years. The registration system that replaced it produced roughly 10,000 patents over 43 years. After the professional examination system was established in 1836, the pace exploded. By 1860, the Patent Office was granting over 4,000 patents per year. By 1900, the number had grown to over 25,000 per year. Today, the United States Patent and Trademark Office issues over 300,000 patents annually, and the total number of patents granted since Samuel Hopkins received his potash patent in 1790 exceeds 11 million. The story of patent law in America is a story about one of the most consequential decisions the founders made, and one of the least discussed. The men who wrote the Constitution could have left intellectual property to the states, the way they left most other commercial regulation. They chose not to. They put the power to protect inventors directly into Article 1 of the Constitution, alongside the powers to tax, to regulate commerce, and to declare war. That choice reflected a conviction that innovation was not a luxury but a necessity for a young nation trying to compete with the established industrial powers of Europe, and that inventors would not innovate unless they could profit from their work. Every patent on every product you have ever used, every pharmaceutical compound, every piece of technology, every machine and process and design that has ever been protected by a United States patent traces back to a single clause in the Constitution and a law that was signed in April of 1790. The first patent was for a process of making potash. The 11 millionth is for something that the people who wrote that first law could not have imagined. But the principle is the same. If you invent something new and useful, the government will give you exclusive rights to it for a limited time so that you can profit from your work before it belongs to everyone. That principle did not exist in America before 1790. For the first 14 years of the country's history, anyone could take your idea, build it themselves, and sell it without consequence. The fact that the founders fixed that problem within 1 year of organizing the new government, making it one of the very first things the first Congress ever did, tells you everything you need to know about how important they believed it was. And the system they built, refined through 3 major acts of Congress and a fire that nearly erased its history, became the foundation on which 11 million inventions and the most innovative economy in the world were constructed.